Hi, this is Mark Zinman. I'm a partner with the law firm of Williams, Zinman and Parham, bringing you your legal question. A tenant of mine wants to have 2 assistive animals in his rental unit. I know I have to allow a seeing eye dog, but why would a person need 2 animals? Do I have to allow that? This brings in a very complex fair housing issue. And the issue always comes down to whether or not the tenant has a medical provider's note demonstrating the need for the reasonable use and enjoyment of whatever accommodation is granted. In this case, they're asking for 2 animals. Now, before we get into the specifics of what's being offered, you have to remember, with every fair housing question, it's always a fact-based analysis. There is no general rule that can apply in every case. You must speak with your attorney when addressing these issues. In this case, if the medical provider signs a note identifying that the tenant needs both a seeing eye dog as well as, for example, an emotional support animal, and that both animals are for the reasonable use and enjoyment of the property, you would have to allow them. Now, under the Americans with Disabilities Act, only service animals qualify. It is very important to remember this distinction, how it is different from the Fair Housing Act, where an animal does not have to be certified, and you as a landlord will have to approve an assistive animal if a medical provider authorizes that animal and approves it for the reasonable use and enjoyment of the property. And again, always contact an attorney with your fair housing questions. Thank you for joining us for this week's legal question.